Hi, this is Wayne Harper of Harper IP Law, and this is a presentation on comprehensive intellectual property protection planning. Please note that the content of this presentation is provided for purely informational purposes. It is not legal advice and does not establish an attorney-client relationship between you and Harper IP Law or Wayne Harper. What is intellectual property? The term intellectual property refers to ideas and information that have value to your business. Examples of intellectual property include business and product names, inventions, documents, business processes, marketing information, databases, software, or graphics and artwork. Most intellectual property can be legally protected, at least to some degree, by one or more legal regimes or business practices. Legal regimes include trademark law, patent law, copyright law, and trade secret law. Business practices include clarity in the ownership of intellectual property assets, agreements to assign intellectual property rights, non-disclosure agreements, and non-compete agreements. Every business should have a comprehensive intellectual property protection plan. The term comprehensive is intended to both reflect the basic concept the plan should cover all of a business's intellectual property of significant value, and should use all available legal regimes and business practices to protect such intellectual property. The process of developing a comprehensive intellectual property protection plan will generally involve the basic steps of identifying intellectual property currently in existence or likely to be developed that is of value to a business, determining what legal regimes and business practices can be used to enhance the protection of the business's intellectual property, estimating the cost of such legal regimes and business practices, determining which of the identified legal regimes and business practices to utilize based on a cost-benefit analysis, and forming a plan to implement the selected legal regimes and business practices. We'll now talk about the legal regimes for protecting intellectual property in more detail. Trademarks. A trademark is a word, a phrase, symbol, or design that identifies or distinguishes the source of the goods and services of one business from those of others. Examples include a word or phrase, graphic logos, sounds, scents, or colors. A business acquires trademark rights simply by using the trademark. Trademarks can often be registered at a state level and/or at a federal level. Registration is not required to use a trademark, and an unregistered trademark can still be defended in court. However, registration is relatively inexpensive and carries certain advantages. For example, a federal registration provides notice to the public of the registrant's claim of ownership of the mark, legal presumption of ownership nationwide, and the legal right to use the mark nationwide. Patents. A patent is a form of intellectual property consisting of a set of exclusive rights in an invention granted by a sovereign state to an inventor or their SNE for a limited period of time in exchange for public disclosure of the invention. In the U.S., there are two types of patents: utility patents and design patents. Utility patents are the type of patent that most people think of when they hear the word patent. Such patents can relate to one or more of four types of inventions: processes, for example, manufacturing processes, or processes implemented using computer software; machines, for example, mechanical devices or electronic devices; articles of manufacture, for example, ceramics, cast metal articles, simple tools, and software stored on a tangible storage medium; or compositions of matter, for example, alloys, drugs, and chemicals. Provisional patent applications. Provisional patent applications are not per se a distinct type of patent application, but rather a way of filing a quick and inexpensive disclosure of information with the USPTO that can be referenced in a later utility or design application. Provisional patent applications are used principally to establish a filing date for patents, referencing the content of the provisional application. For example, to be eligible for patent protection, an invention must be new, that is to say, no one else has publicly revealed or filed for a patent for the same invention. Useful, the invention has to serve some purpose, even if such purpose is not particularly earth-shaking, such as, for example, decoration or entertainment, and it has to be non-obvious. The invention cannot be an obvious modification of a pre-existing invention or a combination of pre-existing inventions. This can be usually the most difficult hurdle. Unlike trademarks, copyrights or trade secrets, patent rights do not automatically accrue by the conception, testing, or use of an invention. The inventor or his S&E must file a patent application. Note that the first person or entity to file a patent application for an invention will obtain any patent rights in the invention, whether they were the first or the 10th person to conceive of the invention. Thus, it is critical to file patent applications relating to an invention as soon as possible, if necessary, as one or more provisional applications. Copyrights. A copyright is a form of intellectual property consisting of a set of exclusive rights granted by a sovereign state to an author of a creative work, such as a novel, a musical composition or recording, a graphic artwork, a computer program. Copyrights are of interest to more than just authors and artists, however. A typical business likely has many works that qualify for at least some level of copyright protection. Such works could include advertisements, websites, manuals, such as user manuals, internal documents such as policy manuals, software, and databases to a limited degree. Any creative work is automatically protected internationally under copyright law as soon as it is created and fixed in a medium of expression, such as on paper, on a CD, a DVD, or computer storage. Copyright on a work can be registered with the U.S. Copyright Office. Registration is not required to obtain copyrights in a work per se, but such registration is a prerequisite for bringing a suit for copyright infringement. Typically, businesses register copyrights for particular works where such works are core business assets, such as software, or such works are sold for profit, such as books or recordings. Businesses sometimes also register copyrights in advertisements to preclude competition from copying highly original advertising copy. The registration puts you, the public, on notice you will defend your copyrights and serves as good evidence of the date of the creation of the work. Trade secrets. Trade secrets are any type of data or information that is of value to a business that the business maintains as secrets. Trade secrets are generally maintained in strict confidence, not disseminated or known to the public. Examples of trade secrets include sales and marketing plans, management policies, customer data such as customer lists, manufacturing processes and other types of engineering information, formulas such as, for example, the formula for Coca-Cola. Businesses may choose to maintain data or information as a trade secret for a variety of reasons, some of which might include formal registration of trade secrets is not required, trade secrets are not publicly disclosed, as opposed to patents where everyone can look at a registered patent. Trade secret protection does not expire. For example, unlike patent protection, which expires 20 years after filing, Coca-Cola's secret formula is over 100 years old and still a trade secret. Information may not be eligible for any other type of legal protection and may still be eligible for protection under trade secret law. Trade secrets can be protected under a variety of state and federal laws. The basic requirement for trade secret protection of information is where the owner of the information has taken reasonable measures to keep such information secret. The information derives independent economic value, actual or potential, from not being generally known to or being readily ascertainable through proper means by the public. Now we'll talk about business practices for protecting intellectual property. Maybe one of the most important things in maintaining intellectual property is being sure who actually owns the intellectual property. Over time, owners, officers, employees, and contractors of a business typically create or enhance various intellectual property assets used by the business, including inventions, creatives, and artistic work, trademarks, and trade secrets. It should always be crystal clear to all parties involved who or what owns such assets. Three of the most common models for structuring the ownership of intellectual property assets are as follows. Intellectual property assets are owned by a corporation that uses the assets in operation, Or, number 2, intellectual property assets are owned by a holding corporation that licenses the assets to one or more operating corporations for use in their operation. 3, intellectual property assets are owned by the creator, like the inventor or the author of the asset, who licenses implicitly or explicitly the assets to one or more operating corporations for use in their operation. Any of the above models can be workable so long as they are properly structured. The first model is probably the simplest and least expensive to implement. However, where there are multiple owners of the corporation, care needs to be taken to lay out in the corporate charter how intellectual property assets can be transferred or sold, and how such assets are to be distributed in the event of corporate dissolution. Agreements to assign intellectual property rights. Where intellectual property assets are assigned to a corporation, all owners, officers, employees, and contractors of the corporation should be required to sign an agreement to assign intellectual property rights prior to performing any work for the corporation. The most important clause of an agreement to assign intellectual property rights would be similar to the following. Name presently assigns and transfers to the company all right, title, and interest, in including any and all intellectual property rights pertaining thereto, any works created, made, conceived, invented, developed, discovered, or reduced to practice in the performance of his, her, or its duties on behalf of the corporation. The wording of this clause, well established by years of practice in case law, operates to automatically assign rights to intellectual property assets without any further agreements or assignments. Some owners or employees may balk at signing such an agreement, but it is essential that they do so. Generally, it is much easier to get people to sign such agreements at the outset of their association with the corporation. Non-disclosure agreements. In a non-disclosure agreement, an officer, owner, employee, contractor, or customer of a corporation agrees not to disclose confidential information of a corporation to any third party, and typically not to use such information for their own personal use. Confidential information can be broadly defined as any information relating to the corporation, its assets, and its products that are not known to the public, which the corporation does not wish to disclose to the public. Examples of such confidential information could include trade secrets of the corporation, employees of the corporation, financial information relating to the corporation, shareholders in the corporation, pending litigation relating to the corporation, and negotiations relating to the sale of the corporation. The duration of the agreement can be for a limited term, say 5 years, or more commonly, indefinite, expiring only when the confidential information becomes known to the general public. Perhaps the most important function of a non-disclosure agreement is to put people on notice that there is information that a corporation wishes to maintain confidential, and unauthorized disclosure of such information may have serious legal consequences. Non-compete agreements. In a non-compete agreement, an owner, officer, employee, or contractor of a corporation agrees not to enter into or start a business in competition with the corporation within a well-defined geographical region during a specific limited time frame. Such agreements can help protect intellectual property because a person's motivation to misappropriate intellectual property assets can be significantly diminished if the person can't use such assets in the operation of a competing business. The law disfavors non-compete agreements, as such agreements can be a significant restraint on both trade and the ability of persons to pursue employment opportunities. Thus, such agreements must be narrowly drafted. In Florida, non-compete agreements must, at a minimum, comply with the requirements of Florida Statute 542.335. The most important requirements of the statute provide that a non-compete agreement must be signed and in writing. The agreement must serve a legitimate business purpose, interests such as, for example, the protection of trade secrets or other valuable confidential information. The non-compete agreement must be reasonably necessary to protect the specific legitimate interest at stake, and the term of the agreement must be reasonable. Bear in mind that when a person is asked to sign a non-compete agreement, it can provoke a very visceral and negative reaction. Of all the various agreements discussed above, non-compete agreements seem the most intrusive, and indeed they can impose significant economic hardship on the signer. The solution to this problem, to the extent one exists, is to limit the scope and duration of the agreement to the absolute minimum necessary to protect the interests at stake. Estimating the costs of intellectual property protection. A detailed discussion of estimating the costs of the various costs of intellectual property is beyond the scope of this presentation. However, any such estimates will generally factor in government and legal fees for applicable registrations, if any, the cost of policing for infringement of the intellectual property rights, and the cost of enforcing intellectual property rights against infringing parties. Bear in mind, the cost of policing and enforcement can vary greatly depending on how aggressive the enforcing corporation chooses to be in enforcing its right. Evaluating the costs versus the benefit of intellectual property protection. Evaluating the costs versus the benefits of various types of intellectual property can be a complex process. But such process at a high level will generally involve estimating the value of individual intellectual property assets, for example, the net present value of the asset over its projected lifetime. Comparing the estimated value of the individual intellectual property assets to the cost of obtaining and enforcing rights in the assets. Then identifying intellectual property assets whose value exceeds the cost of enforcing rights in the assets. Informing the intellectual property. A comprehensive intellectual property protection plan can take a variety of forms, but will typically detail business practices governing the ownership and protection of intellectual property rights and all intellectual property assets, will identify specific intellectual property assets to be protected via various legal regimes, specify the types of legal regimes used to protect each asset, specify how rights in such assets will be policed, specify how rights in such assets will be enforced, and set a schedule for the documentation and/or registration of legal rights in such. If you have any questions, feel free to contact me via my email at wayne@harperiplaw.com or call me at 813-892-7839.